Hey, Tim,
First,
welcome to number nine.
number nine. Here we go.
We're
Amen.
almost in double digits.
Amen. Hey, maybe before we get started, let's talk a little bit about this conference you just came from and the conference you're going to. So we just presented at there, by we, I mean you, just presented at the CASACO Trade Secret event in Boston. How'd that go?
It went great. It was a really good time. So I did both a pre-event workshop, kind of like stretching before you get into the real game, as well as being on a panel dealing with the question of do you track or not track trade secrets, which of course the answer is you track. But yeah, it was a great event. There were over 100 people, very well produced, and just a really good time.
Yeah, and it's amazing. There's within 2 weeks, two trade secret events. This was unheard of a few years ago, right? So
Yeah,
next week,
it's like 2 and 7 days for me. So I'll be out in San Francisco next week at the IAM Trade Secret Conference. So yeah, within 7 days to have two major events, unheard of before. But that just shows how important it is.
awesome. So this case we're going to cover today, uh, Prysmian versus Sterlite. So this is a decision that came down just a couple weeks
Yep.
ago, and this is a follow up to our conversation, our previous pod, where we talked about Italy. And so I guess all roads lead to Italy at the moment. And so we'll talk about this case, which, again, is still a big number. It's just shy of 100 million. But super interesting set of facts here. And so just a quick little setup. So Prysmian is a company that's been around for a long time. It's Pirelli's old fiber and cable business. And so it got spun up into this Prysmian in sort of maybe 2010 timeframe or thereabout. And so it's acquired a bunch of companies. It's now the big player in the market. 30,000 employees, $20 billion market cap, serious player. And then the defendant in this case is Sterlite Technologies, much smaller player, 60 million revenue, market cap of a billion and change. Part of a much bigger conglomerate in India. And so what's kind of interesting here, just to start, is you got two companies who are headquartered outside of the U.S. And this is a case that was brought in South Carolina, as well as a DTSA claim, I believe.
That's right.
And so, and it's kind of the the age old example of senior exec leaves with a lot of stuff, right? And so, so maybe why don't you take us through a little bit of the background of what happened here?
Yeah, and this case for me was interesting because my opinion of it kept going back and forth. Like at first I thought, wow, this is really a good read. And then for a little while I thought, oh, it's kind of like normal slash boring. And then
Yeah.
I kind of went back to, oh, this is actually kind of interesting for a couple of reasons. So it's funny that like the deeper you get, your opinion keeps flip flopping. But yeah, fundamentally, it is the usual pattern of senior executive, takes hundreds or thousands of documents with them, breaking all of their contracts for confidentiality, for non-compete, for non-solicit in the process to join a competitor. So that all was fairly normal. I thought it was interesting that not only were the documents brought to the U.S. entity, so this guy basically left one U.S. entity and then joined the U.S. entity of the Indian company, uh, but then all those documents ended up back in India. So as part of the discovery process in the litigation, turns out he didn't only carry the documents down the street or to the next job, but they actually ended up back in the multinational HQ in India, which is pretty bad thing to happen.
So we got
Yep.
just reading from the
Mhm.
original 2021 complaint, business plan, projects, estimates, costing data, customer lists, technology, technical data.
Everything.
It's kind of like everything, right?
Yeah.
And what was it? Was it 10,000 files or something like that? It was
Yeah, it
a
was.
big
It was
number.
I think it was 10,000 pages, but
Pages. Okay.
let's say 1,000 files at 10 pages each. I mean, it's a lot of stuff covering all aspects of the business. So it's not like he brought, one product or one prototype. It was pretty much the entire business was packaged and carried across the street.
Yeah, it's amazing, and it's it's a
Mhm.
much smaller company
Yep.
too. Looking at this, $96 million,
Mhm.
for a company that's doing, I don't know, just call it 100 and
Mhm.
change in 100 million change in
Yeah.
revenue. Yeah, this seems like
Oh,
it could be
it,
catastrophic.
it could be, and they've said they will appeal already. Like, basically, right, days later, they said we're going to appeal, because you're right, it's like an entire year's of revenue. It's massive. Uh, the other funny thing was, you know, in most trade secret lawsuits, there's a real urgency because you want to prevent, dissemination of your trade secrets, or you want to, control the damage as quickly as possible.
Yeah,
So oftentimes you really scramble to get your complaint ready, to get all the facts lined up, to do, whatever forensics you need to do, but it's very much a rush to the courthouse. Here that didn't happen. They actually waited, it was like 10 months or so, just shy of a year, to file the complaint, which, I have to wonder, did they not figure it out, or were they just super relaxed about it? But that, again, it's very much an unusual time frame. And that's,
yeah.
one of the things that swung me back to thinking that this was an interesting case after all.
Well, and yeah, this idea that you've got, a company headquartered in Milan. You've
Mhm.
got company headquartered in Pune, India.
Yep.
It's like, and now we're going to file a case, in the U.S. under federal law, under state
Yep.
law. I think also just really highlights the power of trade secrets, right?
Mhm.
This is, presumably the misappropriation took place on U.S. soil, and so makes plenty of sense. But we don't see too many cases. I mean, I'm sure there's plenty. Certainly, we haven't looked at too many where you see that fact pattern, right? Two
Yep.
international companies coming to the U.S. And so, I mean,
Mhm.
ITC, we've talked about that. This is
Yep.
certainly a different kind of complexion than some of those ITC cases. But
Yeah, and here it was the U.S. entity or U.S. subsidiary that were fighting it out. So, uh, one was a Delaware incorporated entity, but based in Kentucky. The other one was South Carolina, based in South Carolina. Uh, so it wasn't like, the Indian multinational versus the Italian, like some of the headlines say. Uh, but still,
yeah,
everything fed up back to, Pune in the case of where those thousands of documents went. So it is really a more interesting case than you think originally. But
and one of the
but
things. Oh,
go ahead.
go ahead.
I was going to say, like, even the news media kind of got it wrong. Like, some of the headlines are a little bit off, and then a couple of the websites even misspelled Sterlite to be the Sterlite, which is the plastic storage
Yeah,
bins
yeah,
that you use
yeah,
to store your clothes at home. And yeah, and just to be honest, the first time I looked at this, I thought, oh, this has to do with plastic storage
totally,
bins. I
totally.
didn't
How
I didn't I
interesting.
didn't realize it was optical data cables, like undersea cables.
Totally.
It was pretty funny.
So yeah, I mean, from the original complaint, there's what one of the bits really focused in on valuation models,
Mm.
and apparently um, some communication where the defendant, the executive in this case, like referred to those valuation models, and these are valuation models relating to a plant, as quote unquote absolutely confidential, right? So sounded like a nice
Yep,
smoking gun there.
definitely.
But I think it also, for me, it just really reinforces this idea that, wow, like maybe one of the most important pieces of data here is actually not technical at all,
Mhm.
right? It's just the economics of how this plant is going to be built and make money, right? Um,
Yeah, and we at Tangibly always talk about how there are technical trade secrets that a lot of IP lawyers kind of understand and think about. But then, the soft trade secrets or the business trade secrets are often as valuable or even more so. And this is a great example of that.
so one of the things, in the complaint was, you know, these uh, almost the recitals, right? It's like, here's kind of what happened, and here's what's in the contract. Um, and so it defines, and I'm reading from the complaint, it defines proprietary information slash trade secrets as quote unquote, all information, whether or not in writing, memorized, or verbally communicated, of a private, secret, confidential nature concerning the company's business or financial affairs. Um, and so, look, this is going to get appealed, right?
Yep,
And very
absolutely.
much like this Boeing decision, which we have to do the follow up on still, by the way.
Yep.
But the Boeing decision, the $72 million decision, which we talked about a few weeks ago, got thrown out. Um, and so, as I look at this definition of proprietary information, trade secrets, in some ways, it doesn't really sort of jive with how the courts are behaving, meaning that, it's not just all information, whether or not it's in writing, right? And so I almost feel like these definitions, and it's probably in everybody's NDA, by the way. I don't have ours memorized, but it's like this idea that whether in writing or not, it's like, I just feel like maybe that's a term that's going to need to start to morph, because it in and of itself is probably defining things wrong, isn't it?
Well, I mean, you can have a lot of great trade secrets that are not in writing, like they haven't been written down. Like you might have a technician who manages the equipment and he or she knows exactly which setting all those dials need to be turned
Yeah,
to get an optimized product. And there's no one document saying, dial number 1 is set at 7 and dial number 2 is set at 13. But still, like if that person dropped dead or left the company, you'd have a huge problem because that was super valuable proprietary information that wasn't written down anywhere. So it's kind of tricky. I mean, it's nice when it's written down, but sometimes it doesn't have to be.
but isn't the nature of the Boeing case, and we can look at a few of the other sort of big headline cases this past couple of years.
Yep.
But so I understand what you're saying. I don't disagree with the idea that there's there are bits of information that are critical path to the business. They meet all of the hurdles of a trade secret. But if you're going to go try to litigate what's in that operator's head, you're going to lose, right?
Well,
Um,
the trend is to greater specificity. So if you just say the settings on the machine, that's probably not going to fly because it's too vague and doesn't really particularly identify what the trade secret is. And all these litigations are saying, you have to be more and more specific and you can't hand wave like you used to. So I think we're going to see a trend towards, tightening up what people actually believe is their trade secret. And
yeah. So,
that's
so I
probably a
guess
good thing.
that's why I'm kind of reacting to the definitions that are in everybody's NDAs, right? As
Yep.
being like, and so look, maybe, and I'm just sort of thinking this through as we're talking here, but like maybe as a 50,000 foot cover, right? Like you want to say, hey, Chris, even if it's not written down, it still could be a trade secret, right? Um, But if I go down to 30,000 or 20,000 foot, I may say, yeah, but if I really want to litigate this trade secret or really, really protect this trade secret, I better write it down, right?
Yeah, and this actually came up in Boston at the conference of whether NDAs are really that useful or not, because they're usually written very broadly, like evaluate business relationship between company one and company two, which doesn't say anything. So we were even talking about the idea of having multiple NDAs, like as the conversations get more specific, or as you need to discuss trade secrets with more detail, you do NDA sub one or sub two or sub three, and you might end up with multiple. But psychologically, people think, oh, we've got an NDA, open the gates, like it's all good, and it's really not.
Yeah, I if and again, this is a something for tangibly to figure out in software. But if you make that process easy, right, to execute maybe more stringent NDAs as as a relationship develops, I think it's I think it would be well received. The other thing, and I had this same feeling once we got into this, I was like, just another boring $100 million case of some executive stealing stuff. But I've come to enjoy reading these cases, and some fun stuff kind of drops out here. And so when they were discussing sort of loss of business, right? And so Prysmian was basically saying, hey, somebody stole something, we lost a bunch of business. And then basically two witnesses, from Prysmian basically said, they're producing its fiber optic cable at full capacity and cannot meet its customer demand. So it's like, well, I guess that argument doesn't hold so much. So anyway, it's funny reading that kind of stuff in here.
Well, and we were joking at the conference that the E in email doesn't mean electronic mail; it actually means evidence mail.
So, that's awesome! I've never heard that before.
Yeah, it was kind of a half joke, half serious comment, but
that's funny.
So many cases turn on emails. Like it's not so much how people behaved, but if you have a poorly worded email or an email that you tried to be funny or joke and didn't quite reach that point, they can be super damaging. So you have to be careful with your evidence mail.
100%.
The other comment you said, this is another boring $100 million trade secret case. That's actually an amazing thing to say, because not too long ago, the only way you could get to a $100 million case is through patent infringement. And the fact that you and I are now being bored by a paltry 100 million in trade secret, in a way, is fantastic, because it's saying we're playing in the same sandbox as patent infringement, and trade secrets are equally financially important. So it's funny that we're both kind of bored by $100 million.
But when you get into the details of the case, it's no longer boring.
Exactly.
But point taken. And one of the things we should do, let's add to our docket to do a kind of a win-loss comparison and a damages comparison. That would be fun to kind of dig through. We've got a lot of that data, and we've been going back and forth on that recently. And I think if we put the PTAB data in there as well, not just sort of jury trial, patent infringement, things that make it to trial, I should say, like that would be really interesting to kind of look at all that data. One more thing that's in here that I thought was worth mentioning is Prysmian, this is from the complaint, has a clean desk policy to protect its information, and does training to remind employees about the importance of confidentiality. So again, those are those types of best practices that come in really, really handy in a case like this. But I gotta say, like I'm excited to see what falls out of the appeal here, because it's certainly it very much could start to, mirror that,
Yeah, the Boeing.
Boeing
Yeah.
Unum decision. So let's see, because I think what we're seeing in these appeals is like we're getting into the weeds, right? Let's see exactly the gory details of the trade secret. So anyway, be interesting to see what happens. All right, I think we're at time, Chris. Let's call it number 9. Great stuff. Number 10 is coming, and what are we going to talk about next?
Oh, so I'm voting for the Motorola Hytera case, which is fascinating because a lot of it happened internationally. So it's really extending trade
Yeah.
secret protection beyond the US to cover international activities. So that's my vote.
All right, let's do it. Let's
Awesome.
call it a day. Good seeing you.
Thanks, Tim.